Hi, welcome to the Oregon Conservation Partnership webinar. Today we're going to talk about after the quarantine, practical tips for reopening your workplace. We want to first thank OWEB for supporting this presentation. Our presenters today are from Markowitz Herbold PC, a Portland law firm. We have two presenters. Kyle Buss has 13 years of litigation experience in employment-related cases, and most recently was named among the best lawyers in America, 2020 Portland Lawyer of the Year for employment law. So we have the right people here today. He currently advises both employers and employees about strategies, policies, and best practices for getting back to work in these uncertain times. We also have with us Laura Salerno Owens. She is actually the president of the firm and chair of the firm's employment practice. She's argued and won key cases representing employers in high-stakes employment issues. In the past 2 years, she's been recognized as one of the top 100 influencers in the U.S., a Woman of Influence honoree, and as one of the under 40 honorees. So questions sent to us in advance were worked into the presentation. If you have questions as we move along, you can put them in the chat box. We may not have time for questions at the end because this is a pretty solid presentation, but if they're in the chat box, then the presenters will get back to you with answers. So Laura, you're on.
Great, thank you so much. And thank you everyone for joining us today. Kyle and I are really excited to be here, and this is obviously a very timely topic. In fact, Kyle and I have presented on this before, and just yesterday we had to revamp many parts of the presentation because the news just keeps coming fast and furious. So I'm really glad to have you all here. I just want to give you a general overview of what we're going to talk about today, because as Jen mentioned, it's a jam-packed hour of content. So we're going to be going over quite a bit. We might be going a bit fast, but don't worry. Hopefully the materials that we provided to you will help you follow along. So you should have received beforehand both the slides and our resource packet. And our resource packet has sample remote work policies, sample social distancing policies, a checklist for you to consider when you're reopening your workplace. So hopefully you can rely on those written materials. And then of course, as Ann mentioned, should you still have questions that are not answered, feel free to reach out to me and Kyle. So that being said, here are the three things that we're going to talk about today. First, we're going to start by talking about the process of reopening. And this is really going to be some nuts and bolts practical consideration. Then we're going to move to the frequently asked questions. A number of you presented questions beforehand, which we really appreciate. Thank you so much for doing so. And we're also going to weave in the questions that we have received from our clients in other circumstances that we think will be relevant to the issues you're dealing with. And then finally, we're going to talk about some legal considerations. As many of you may know, there is a new law, the Families First Coronavirus Response Act, or the FFCRA. So we're going to talk about that law. And then we'll also talk about how, even with some existing laws, the COVID-19 situation gives you a new analysis, a new context on how to apply existing laws in the workplace. So that's what we'll talk about today. And without further ado, I will turn it over to my colleague, Kyle.
Thanks, Laura. Just making sure I'm unmuted. Okay. Hi, everybody. I hope you're staying safe and healthy out there. Thanks again for being with us. I'm going to start off by talking about the challenges that most cities are currently undertaking, most employers are currently undertaking, and that is the process of reopening in a world that is totally unfamiliar. We're entering uncharted waters, and there are a lot of balls in the air for employers who are having to balance their duty to employees to provide a safe and healthy workplace with the unique financial pressures being applied by the global pandemic. I'm sure this is particularly true for your districts, which rely so much on dwindling public funds and grant money. It's a heavy lift, and because we've never been through anything like this before, there is no history or precedent or institutional knowledge to guide us. One thing you'll hear a lot today is that communication is key. This is because in a situation like this, where we're all figuring this out as we go, which will lead to complications and mistakes, making people feel included and informed is going to be key to not making things even more difficult than they already are. So let's start by talking about where we are and how we got here. The reopening started May 1st when Governor Brown lifted her order delaying non-urgent medical procedures. On May 5th, she began announcing additional reopening guidelines, including those for parks and restaurants and bars and something near and dear to my heart these days, childcare and youth programs. 31 of 36 Oregon counties began phase 1 reopening on May 15th. Phase 1 reopening included restaurants and bars reopening, but with restrictions. This picture on the left is my favorite solution I've found so far to social distancing in restaurants. This is a restaurant in Hong Kong that ensured that people were properly spaced by occupying tables and chairs with very well-dressed mannequins. Personal care services have been reopening, also with restrictions. These guys on the right figured out the art of long-distance barbering. Gyms and fitness clubs have had limited reopenings, and local gatherings are allowed for groups of under 25, but the 6-foot rule still applies. So many of you living in those 31 counties have been able to enjoy some of the loosened restrictions since mid-May. In order to move to phase 2, counties had to remain in phase 1 for at least 21 days without significant increases in COVID-19 cases. For 26 of those 31 counties, phase 2 started June 5th, less than 2 weeks ago. Phase 2 reopening includes, subject to public health guidelines like social distancing, gathering size limits, and sanitation practices. Phase 2 allows counties to bring back things like movies and theaters, bowling alleys, arcades, pools, and other recreational sports. Bars and restaurants can stay open until midnight again. Social, civic, and faith-based gatherings can meet in larger groups, although we'll talk about how that has become a little bit of a hot topic just in the last couple of days. And most relevant to what we're discussing today, the restrictions on in-office work are loosening. Some of you are actually getting back to the office, or will be very soon. This is where most Oregon counties are, though not necessarily most Oregonians. As you'll see from this next slide, Multnomah County is the only county which has not even gotten phase 1 approval yet, although, well, gotten to phase 1 yet, I should say. Just yesterday, they were approved for phase 1 on Friday. We'll talk about that. But as you can see, some of the most populated counties in Oregon still haven't been approved for phase 2. On June 12th, the governor paused reopening for 7 days. June 12th was supposed to be the day that Multnomah County entered phase 1. And so the governor's pause meant that Multnomah County couldn't reopen according to its scheduled timeline. And yesterday, which turned out to be a very big news day, the governor announced that Multnomah County will in fact enter phase 1 on Friday, which is June 19th. As part of her order authorizing Multnomah County to open on Friday, the governor made a few other very important announcements. Highlights include that Marion, Polk, and Hood River counties can enter phase 2. Also, Multnomah, Washington, and Clackamas counties, as well as Marion and Polk counties, are going to be grouped together in regional units because they're so highly connected by urban areas. As a result, to the dismay of many people in Washington and Clackamas County, those counties are going to be reset to Multnomah County's timeline for entering phase 2. In other words, they're going to have to wait an additional 21 days for Multnomah County to catch up, even though they're both already in phase 1. In that same order, Governor Brown has ordered that starting next Wednesday, June 24th, face coverings are required in indoor public spaces in Multnomah, Washington, Clackamas, Hood River, Marion, Polk, and Lincoln counties. So that's a very big development that is going to change the way that we do things in a lot of the major metro areas. Finally, Grant County has voluntarily returned to phase 1 after seeing a huge spike on positive tests from 22 on Sunday to 242 on Wednesday. That outbreak was linked to a church outside of La Grande, and that's what I was referring to earlier with these phase 2 social, civic, and faith-based gatherings. There are obvious concerns all over the state now about how that's going to play out in counties that were already in phase 2. So, and if you look at the end of this timeline, we're a long way off from phase 3 in any county. Phase 3 would include reopening of the highest risk activities like large public gatherings, concerts, live sporting events. The governor's made it clear that this won't happen until a reliable treatment or prevention is available. And at this point, all large gatherings are canceled or significantly modified through at least September. I'm reading articles that have already started talking about October, but even October seems extremely unlikely, if not impossible, given the requirement of treatment and prevention options, which we just, I don't think we see the light at the end of the tunnel on those. So, so that's where we are. Before moving to the next slide, I do want to highlight 2 dates that we skipped over that are worth noting for this group. First, this Tuesday, June 16th, 2 days ago, the OHA announced 278 new cases in Oregon, and that's the highest daily count yet. And I think we've had 8 or 9 out of the last 14 days where we've had a new record for highest daily count. So that's very concerning, obviously. And it shows that despite what seems to be the perception that things are starting to return to normal, I can tell you that, you know, as I walk around my neighborhood, I hear people, you know, in their backyard with more people than I know live in that house, and, you know, things like that. People are starting to think you know, we're getting back to normal. And, you know, it's really important to look at these numbers, though, and realize that we're not out of the woods yet. These precautions that we're all taking about reopening are still very meaningful because the risk is still very real. The other slide, or the other cell that we skipped over was, as of yesterday, June 17th, 2,818 COVID-related lawsuits had been filed in state or federal courts. We hope that some of what we discussed today will help you avoid becoming an updated part of that statistic. So that's where we are. Every city in the state, even in Multnomah County, is either currently grappling with reopening issues or is about to. And based on some of the questions that we received before this presentation and the survey that went out last month that some of you, I'm sure, filled out, we reviewed that. It's clear that questions remain about the extent to which your districts can reopen and how far they should take reopening, even if they can technically bring employees back to a more traditional office environment. After all, as we learned from Jeff Goldblum in Jurassic Park, just because we can do something doesn't mean we should. Seriously, though, it is important to consider whether remote or modified work is a better choice for your specific situation, given the uncertainty we're facing as we begin the reopening process. Before deciding on who comes back, when they come back, and what that's going to look like, you should do a thorough risk assessment. And if you already have employees back in the workplace, it's not too late. Excuse me. Since OSHA requires employers to provide employees with a reasonably safe workplace, a COVID-19 specific risk assessment of any physical work environment is a best practice, even if it supplements what you've already done. This is especially true because OSHA agents are going to consider a business's good faith efforts to comply with COVID-specific policies if a complaint is made by an employee or by a member of the public who comes into your workspace. So not only is this information going to be important to actually fostering a safer workplace for employees to return to, but it also could potentially keep you out of trouble. When conducting the risk assessment, you should classify the exposure risk level of the various roles in the workplace in accordance with OHA guidelines and take appropriate steps to protect workers with medium, high, and very high risk exposure jobs. If and when your city does decide to move forward with conventional reopening, there are a few steps you should consider. First, Decide whether you'll conduct testing. This is legal and it can be done on site. If you do decide to do this, make sure to check a few boxes. One, make sure you have trained personnel conducting the tests, whether it's an actual COVID test or just a temperature test. Two, establish clear and uniform standards for testing. Three, communicate to employees in writing what you are doing, how you're going to do it, and what happens if the results are positive. Four, apply the test uniformly. An employer should not pick and choose who gets tested, or it will create the perception of discrimination. And keep in mind that these guidelines apply to testing for the active virus and temperature testing, both of which are authorized under ADA guidance. This does not apply to COVID-19 antibody testing. We released guidance just yesterday saying that antibody testing is not authorized under the ADA. So we can't do that. Now that's something that could change. We want to keep an eye on that. EEOC is being guided in large part by the CDC, but for now, no antibody testing is authorized. One question we've been asked a lot is about employee handbooks, and specifically whether employee handbooks should be updated to reflect quote unquote after quarantine conditions. Our advice is, rather than updating the entire handbook to include after quarantine conditions, our suggestion is to take two related steps. First, take the opportunity to review and update current employment policies. Particularly important are policies already in place, such as family medical leave, sick leave, employee leaves of absence, telework, vacation, and paid time off. Second, create a COVID-19 specific addendum to the employee handbook. And, you know, in addition to what is very obvious, like policies around social distancing and PPE, consider including policies about requiring employees to report illness, workforce contact tracing, special accommodations for vulnerable employees, even if not otherwise disabled. Those are some things that you might think about including in that addendum. Employers should also be diligent about educating employees and possibly create new employee assistance procedures. Make sure employees know how to report concerns, how to file complaints, how to request reasonable accommodations. Employers should also consider choosing a specific individual to receive COVID-19 related inquiries and complaints. Finally, we received a question about how to draft a reopening plan, which incorporates these considerations among others. The answer to that question is that there's no one size fits all for reopening, for any reopening. So there's no real template that we can give you. But any reopening plan will, you know, have a certain amount of consistency, but they do have to be tailored to your specific situation, and that's going to vary depending on things like office layout, number of employees, whether and to what extent employees' schedules bring them into contact with one another, and the kind of field work employees are doing, both independently and in groups. A helpful guide for coming up with questions that you should be asking when coming up with a reopening plan is a checklist that we provided. I think it's Appendix A. Yeah, it's Appendix A in our materials. It's a great guide for asking the right questions when you're coming up with a reopening plan. And it gives you some categories of things you should consider in addition to those I've mentioned. Ultimately, just like with most written policies or employee handbooks that you give to your employees, it's always a best practice to have a lawyer look at it to help you with finishing touches and putting a reopening plan together that is appropriate to your specific workplace. With that, I'm going to turn it over to Laura.
Thanks, Kyle. So what I want to talk about now are some of the issues you should be considering with respect to your employees when you reopen. In a moment, we'll talk about your workplace, social distancing, but for now, let's talk more about sort of employee relations and your communications with your employees. So I think there really are two parts to this inquiry. The first is, what is it you're going to tell your employees about coming back to work? And then the second is, how are you going to be prepared to respond to questions that you can reasonably anticipate getting from your employees? And as to that second point, I think it's really important that you think ahead of time about how you might respond to certain inquiries, because in my experience, it's often when people are responding off the cuff or having a knee-jerk reaction or an emotional reaction that unfortunate things are said, and that can lead to problems and potentially even a lawsuit. So I think it's a really useful exercise to think through both what you're going to tell your employees and how you might respond. So let's start with the first piece, your notification to your employees, what you're going to tell them. And the question we've been receiving from employers are basically two sides of the same coin, which is whether employees are going to return to the office. So the first question we've received is, do I want my employees to return to the office? And if I don't, if I've done a risk assessment, like the type that Kyle mentioned, and I have determined that I cannot maintain a safe workplace with all the social distancing requirements and the cleaning requirements, such that I want employees to continue working remotely, can I require that? And can I require that even though when I hire these employees, they were hired to work in the office and they may not want to work remotely? And the answer is yes. An employer has the right to set the terms and conditions of employment, and those can change. Unless you have a written contract with someone that says to the contrary, in your general at-will employment agreements, the employer can change the conditions in which you work. Employers could move offices, and in a sense, you might think of this as an office move. Employees now are working remotely. So that's the first piece. If you've decided that it's better for your business to have people continue working remotely, you can do so. Now, of course, on the other side of that coin, if you decide that you want your employees to come back into the office, you certainly can require that as well, even if the employees don't want to come back. So let's start talking about that next piece of what some reactions might be from your employees. So employees who don't want to come back, and there could be a variety of reasons for this. You could have employees who just like working remotely, like working on their own schedule. Maybe they have a long commute that they now no longer have, and it's been really nice for them to get that time back in their day. And you could also have employees, and this we've been getting a lot of questions on, who have a generalized fear about contracting COVID-19 in the workplace. So as to the first point, people who just like working remotely, their preference on work is not a legally protected activity, right? As an employer, you can set the terms and conditions of work, and as an employee, they can decide whether they like those terms and conditions. But the second point can get a little stickier and a little trickier, which is, what do you do if you have an employee who says, well, I'm scared to come back to work because I am worried that I'll be infected with COVID-19? So let's walk through a hypothetical so you can get a sense of how you might respond to the situation. And of course, you may not have the same exact facts of your workplace, but I'm hoping this hypothetical is general enough that you can use the framework within your workplace. So imagine we have Jane, who is a healthy employee, and she's needed to handle front desk inquiries. So she has to work in the office. Remote work or telework is not an option for her. And she says she cannot report to work because she has a baby, and she doesn't want to possibly be exposed to COVID-19 and bring the virus home. Now, on the one hand, Jane's position is very understandable. Babies have no immune system or very weak immune systems, and you could understand that a new parent might be concerned about exposing their child. I would also add that we've been seeing this question not just from new parents, but also from some older employees who are grandparents, and perhaps they have a new grandbaby that's in their bubble, and they've expressed concerns about coming back to the office and being exposed. So imagine this is the scenario. Let's walk through what the legal considerations are that you have to consider in this type of case. So the first is, does Jane fall into one of the 6 categories of FFCRA leave? And you may recall from the beginning, that's the Families First Coronavirus Response Act, a relatively new law that went into effect on April 1st. So let's analyze whether Jane falls into FFCRA. Well, the first area is she subject to a federal, state, or local quarantine or isolation order related to COVID-19? One question we've received on this is whether the shelter-in-place order that we had here in Oregon qualifies as one of these quarantine orders, and the answer is yes. But of course, in this scenario, there is no such order because, with the exception of Multnomah County, and that will change tomorrow, everyone's in phase 1 or phase 2. So there's no more shelter-in-place order. So that wouldn't apply. So then the next inquiry is, well, is Jane under the advice from a healthcare provider that she needs to self-quarantine due to COVID-19 symptoms? And again, in this scenario, no, she's healthy. She just has a generalized fear of contracting the virus. So then the next issue is, okay, well, is she experiencing symptoms or seeking a medical diagnosis? And again, the answer is no. So then you move to the fourth point, which is she caring for another individual who's either subject to a quarantine order or experiencing symptoms? And the answer is no, neither she nor her baby have symptoms, she just has a generalized fear. And then finally, and I think this is a category that's covered a lot of employees and impacted a lot of employers, is Jane caring for a child whose school or place of care is closed or childcare provider unavailable because of COVID-19? And of course, in this situation, her baby's too young to be in any sort of school or summer camp or anything like that, so the answer is no. So you can see you run through these categories, none of them apply to Jane's situation, so you don't have to worry about her being an eligible employee under the FFCRA. But that's not the end of the inquiry. There are other laws that might apply. So let's take a look at those. So next, you need to consider whether Jane or her baby has a disability or a serious health condition such that the ADA or FMLA may apply. Keep in mind that we still have these existing laws. If Jane had a disability, you still need to consider whether telework is a reasonable accommodation, or if her baby had a serious health condition, she might be eligible for FMLA leave. But again, in this hypothetical, neither one of those situations exist, so those laws don't apply. So then you go to the third inquiry, and this, I think, is really where the rubber meets the road, and an issue with which many employers will be grappling in the weeks and months to come. And that is the concept under OSHA of whether you have a safe workplace. And the relevant inquiry is whether Jane is subject to immediate danger if she reports to work. That's the standard. And so the idea is that, as Kyle mentioned earlier, all employers are obligated to provide a safe workplace for their employees. And if your employee comes in and says, well, I cannot report to work because it's unsafe, I will get sick, what do you do? Well, in that situation, this is where the social distancing and cleaning and sanitation procedures that we're about to talk about will really be important. I recently attended a webinar with the head of OSHA, and there they reported that what they're looking for in workplaces, because I think in just March, they received more complaints than they had received in all of 2019. So employees are calling and complaining. They're really looking to see that the employer has implemented some sort of social distancing policy, some sort of cleaning procedure, and is applying that consistently and faithfully, and that they're taking a reasonable effort. And if you do that, then you should meet your standard, and the employee should have to report to work and should not be exempt from reporting to work under this imminent danger exception. So let me give you an example of what this conversation might look like with Jane. Jane may say to you, hey, I work at the front desk. I'm worried that I'm interacting with all these different people coming in. They're talking to me, they're breathing on me, and I'm going to get sick. It's an imminent danger. It's too dangerous for me to come in. And you could say, well, I hear your concern, but here are the things that we've done to make you safer. We've put in a plexiglass screen or some sort of plexiglass barrier between you and people who are coming to the front desk. Or perhaps in addition, people have masks. So anyone who comes into our building will have to wear a mask, and you'll be wearing a mask. And then maybe she says, well, okay, but I'm worried about papers. If they hand me papers and their hands are dirty and the virus is on the paper, and then I grab the paper, then I'll get sick. And you could say, all right, well, in response to that, we have gloves that you can use when you're handling documents. And we're actually requiring that before anyone comes in the building, we have a sanitation station right at the door, or a hand washing station. And you have hand sanitizer at your desk, so on and so forth. So you can see what this dialogue might be like. And then after you go through this full inquiry, to get to the bottom line, if Jane is not eligible for any protected leave or doesn't fall under any of these categories, and she still just says, well, I don't feel safe coming to work, you're not required to allow her to work remotely. Her job requires that she comes in and she doesn't have any other protection, then you could at that point separate if that was your last conclusion under a legal standpoint. Kyle and I will talk about the importance of flexibility in working with your employees, but I do want you to know that there is somewhere a line in the sand onto what your obligations are legally as to accommodating remote work. So let's start talking about some of the social distancing procedures you can implement so that when you have the conversation with your employees, you know what to tell them. And so you can document all of these steps you're taking. So if you ever do get a visit from an OSHA inspector, you can clearly show them what you've been up to and what you're doing. So the first, of course, might seem rather obvious, but think about your office configuration. Where are your desks? Where is the furniture? And move things around so you have at least 6 feet space. Now, of course, that may not work if your office is a bungalow. You know, if you're a really small office out in the field, that might be more pertinent for people who are in more traditional office buildings. But I think you understand the point that wherever your physical location is, really think about how you can move things around to create more physical space. Another thing to think about is if you are in a more traditional office setting, to have directional signage on the floor. So for instance, our office, we are all on one floor and you can have arrows that just have people go in one direction. So people aren't passing each other in the hall and not able to observe that 6 feet of space. Some of you may have seen that in grocery stores. They have aisles that go one way for that reason. Another tip or option is to create work zones. So if you have one department that is in the northeast corner, and maybe your finance department is in the southeast corner, and they need to communicate with each other, then make sure that those communications still are remote. They still have to do a phone call or Zoom call or whatever it may be, and they're not walking to each other's area. And that's another way to both limit the contamination among the people and also the workspaces. And then, of course, many I'm sure you've heard about of just thinking about fewer in-person meetings or staggering shifts, which we'll talk about in a moment, or establishing a maximum capacity for your restrooms, or even closing your common break rooms, or if you are going to keep them open, having a limit about how many people can be in there at a time. Now, one question that we did receive ahead of time, and this is a great question, is what do you do about when you have to go out into the field, right? And let's say you have a company-owned car. How do you have social distancing in a car like that? You know, does this now mean that you have to have, if you have 3 people need to go out, all 3 of them need to take their own cars, and now we have to do mileage for 3 people and triple the cost? And, you know, what's the guidance here? And while there's no exact answer for districts per se, I think there's some useful guidance in the context of labor, housing, and agricultural employment. And so, there's a temporary administrative rule that says for cars, what you really want to try to endeavor for is 3 feet of social distance. So opposed to the traditional 6 feet, it's 3 feet. And there's a couple of tips that all people in the car are wearing masks, that you might have someone who is driving in the front and have the other person be a passenger in the back to help with that spacing, that you might also consider even putting in a plexiglass barrier between the front and the back seat. Think about how some taxis, does anyone remember taxis before the days of Uber? Some taxis have that, where you can have that barrier. And then also thinking about maybe creating little pools of groups that, like, this is the carpool group, it's just these 2 individuals, we're not mixing it up as much. That can help limit contamination. And then, of course, just good cleaning procedures, you know, cleaning the high touch points and doing regular sanitation. So those are some tips you might consider for work-related transportation that can help with this social distancing. And then the final point on the slide is a really important one, which is the need to have someone who's enforcing social distance policies. This was required by the governor's executive order, and it's something that OSHA says that they're looking for. When they come into a workplace to do an inspection, they want to see that there is someone who's in charge to making sure that all these procedures are being followed. And I will say, as a practical matter, in my experience in advising my employer clients and even in running our law firm, it's helpful to have one person whose job it is to keep everyone apart, because it's not natural, it's unusual. And so it's useful if you have someone who that is their responsibility to make sure these policies are being followed. So quickly, one other aspect of social distancing is modified scheduling. So really give some thought into whether you can do this. And let me give you an example, 2 examples of what I've seen employers do. One employer I know has broken their workforce into sort of Team A and Team B, I don't know if there's been any office politics about who's on team A and who's on team B, but they're in 2 teams. And team A is in the office Monday through Thursday of the first week. And then while team B is working remotely. And then on Friday, everybody works remotely while they have professionals come in and do a really deep clean of the office. And then the next week they switch. Team B is Monday through Thursday with team A working remotely. And then again on Friday, everyone works remotely with the deep clean and so on and so forth. So that's one example of modified scheduling to just limit the number of people in the office. Another example could be, of course, breaking up into the week, having some people work maybe Monday through Wednesday, and maybe other people work Thursday through Saturday. And as I have said before, please, I do not want people to say, oh my God, Laura Salerno-Owens said you now need to work on the weekend. I do not want that reputation to become the least popular person in Oregon. But I do want to suggest that you might think about whether that's an option. Of course, talking with your employees and in collaboration. And then of course, if you have any sort of unionized workplace or written employment agreements, you have to think about all that. But be creative. And then when you come up with a solution that you think will work, make sure to talk to your favorite employment lawyer about that, because there are wage and hour considerations. You don't want to get into hot water there. But it is something to consider for your social distancing. So then the final thing I'll talk about at this point is we have received some question about contact tracing. Basically, if we have members of the public coming in to our office, do we need to record who's coming in, how long they stayed, get their contact information so that we can then chase that down if someone gets sick? And our general advice is that people do not do this if they're not required to by their county. And the reason being that there are some privacy implications involved with the people or the public who are visiting. And there are also just the practical issues of record retention and what are you going to do with this information and how long are you going to keep it? That being said, contact tracing is being handled county by county. So I recommend that you reach out to your county and figure out what they're doing for contact tracing and what their recommendations are. And with that, I will turn it over to Kyle to talk more about the exciting world of cleaning and sanitation.
I was just about to say, let's jump into the exciting world of cleaning and sanitation. So thank you for sending me out there, Laura. So yes, let's do. So a question that we see a lot is just generally, if people are getting back to work, do I need to conduct daily cleaning of spaces and surfaces? We're not used to doing necessarily any sort of comprehensive daily cleaning. But it's not required as of now, but it is certainly best practices to do that, and I think that it would look good to OSHA and to all of your employees and to the public if you did so. Certainly, you want to do it at least once a day. Excuse me. And if there are shift changes where employees are being replaced, clean between shifts. You want to clean and excuse me. Clean and disinfect all surfaces that are frequently touched by multiple people, like door handles, desks, phones, light switches, faucets. And yes, I did just say clean and disinfect. The CDC guidance says to clean all frequently used surfaces with soap and water first, then disinfect that surface using an EPA-approved disinfectant. An EPA-approved disinfectant is one that meets EPA's criteria and that is effective against the SARS-CoV-2, which is the virus that causes COVID-19. CDC does say that if you don't have the appropriate disinfectant, you can use a solution equivalent to 1/3 cup of bleach to a gallon of water or a 70% alcohol solution. Keep in mind those bleach solutions are only good for 24 hours after mixing. So that's, I mean, we are getting really granular about that, but that is the CDC recommendation. Other things to consider for cleaning and disinfecting, schedule hand washing breaks. So employees remember to do that and feel like the practice is being encouraged. You do want to make employees feel like that's something that you want them to be doing and taking the time to do. Assign people to rotate through the workplace to clean and disinfect surfaces. If everyone takes a turn, it could be a good team building exercise because we're all taking care of each other. Do keep in mind though for this one that when tasked with cleaning a surface for the first time in a little while, that employee is going to be at a higher risk of infection. So you need to definitely provide PPE to any employee who is being asked to do that. Schedule a relief person to give service desk workers and cashiers an opportunity to wash their hands and get some fresh air. Those are high stress jobs right now. Finally, take cleaning and disinfecting out of the equation if you can. Laura already talked about moving furniture around. That's a great idea. Just simply removing unnecessary items from the workplace. It's not just good for social distancing, it eliminates a potential virus transmitter. And this could apply to anything from a chair in an office lobby to a community stapler. If it isn't an essential tool or if it's redundant, consider putting it away for now. It's a really easy way to eliminate risk. In general, try to think of things that are open and obvious efforts to take care of your employees. Just the perception that you're doing so will reduce tension and fear. And it will also be useful to be able to point out good faith efforts to maintain a safe workplace if something does go wrong. Okay, let's turn to personal protective equipment. Probably the most common question we get is, may we require our employees to wear masks? And the answer is yes. The EEOC's guidance states that an employer may require employees to wear personal protective equipment, including masks and gloves. The follow-up question is usually, do I have to pay for that? And the answer is yes. States have different rules about this, but Oregon requires that employers pay for PPE used to comply with OSHA standards. And the Oregon Health Authority says that if employers are going to require the use of cloth face coverings, they must provide them to their employees. Also, from just a Jeff Goldblum philosophical standpoint, even if you have to, you probably should. If you're going to require them, provide them. Also, and this is extremely important, if you're going to require PPP of anyone, require it of everyone. Of those 2,800 plus COVID-related lawsuits that got filed, one of them involved an employer with more than 100 employees, but it only required one person to wear a mask, and that person was Chinese. That is not a good look. I'm sure that wouldn't happen to you, but a less obvious mistake could be made if we aren't applying the rules uniformly. So make the rule, apply the rule uniformly, and don't make exceptions that are not legally justified, like where a medical condition might prevent use of gloves or a mask. And in that case, still figure out a way to accomplish the same goal, such as remote work or scheduling flexibility. Finally, similar to what I said earlier about being very public about your efforts to create transparency and relative calm, the best practice is to very openly train employees about any rule changes related to a reopening. That could be social distancing or PPE or sanitation. Just make sure everyone is trained and everyone knows that everybody else is also being trained. Again, uniform application and no exceptions without a very good and recorded reason. Another question we often see is, can I send an employee home if they're displaying signs of COVID-19, even if they don't want to go home? The answer is yes. Employers may send an employee home if they have COVID-19 related symptoms. The EEOC issued updated pandemic guidance that permits employers to send a sick employee home under the ADA if the illness is serious enough to pose a direct threat to the employee or the employee's coworkers. And according to new EEOC guidance, the COVID-19 pandemic meets that standard. A related question that comes up a lot is what to do when an employee actually tests positive. This is one that I believe we got from one of you before this seminar. It's a very important question. I would suggest thinking about this in three parts. One, what do you do with the employee? Two, how do you communicate with the employee's coworkers? And three, what do you do with the work environment from a cleaning standpoint? The first is simple. Send the employee home with instructions not to return until they've met the criteria to discontinue home isolation. they have consulted with a physician, and they have notified the local state or local health department. Regarding communication to coworkers, you have to inform them of their possible exposure to COVID-19 in the workplace, but you cannot provide the name of the employee who tested positive. It will be obvious in some cases, but nonetheless, all you can say to a coworker is that they have possibly been exposed to COVID-19 and really nothing else. In addition to informing them that they may have been exposed, you should tell them about what you are doing to mitigate the spread of the virus, including sanitation or isolation of a particular work area. And of course, you should encourage the employee to seek medical attention if they start to exhibit any symptoms. Finally, follow the CDC cleaning and disinfecting recommendations for the space used by the employee. Normally, this won't include quarantine of the entire workspace, but it will be a case-by-case analysis. And so you want to be careful about making sure you do that and that you document it. As with everything else we're talking about, be transparent about these protocols. Make sure people know that these are the steps you're going to take in the event an employee tests positive. The best example I've seen of an employer handling a positive test was when an associate at Zupan's Market in Portland tested positive. The market got right out in front of it. They didn't just tell their employees, they told the public what their protocols were so that the public also knew whether they might have been exposed to this associate just based on dates. Obviously, they didn't release who the person was. That's online if you want to look it up. There was some press about how they handled that. Finally, we got some questions about sending asymptomatic employees home if they've been in close contact with someone with COVID-19. You can do that. You just want to make sure that the person falls within one of 4 categories. They could have had close contact, which is 6 feet or less, for a prolonged period with someone who was symptomatic. They could be a household member of a symptomatic person. They could be an intimate partner of a symptomatic person, or they could be providing care to a symptomatic person without using the recommended precautions. If an employee fits into one of those categories, you could send them home. Okay, I only have a few minutes left. I want to make sure Laura has some time to talk about the FFCRA, but there are a couple of other questions we received. One of them is issues to cover in a remote work policy. I'm sorry, I skipped a slide there. Let's just go straight to remote work. That's good. So next slide, please. There you go. So remote work policies, they're all a little different. The best ones that I've seen contain a few basic things. One is an admonition that remote work is job specific. Not every job is conducive to remote work, and particularly jobs that require you to come in, go out in the field, do some testing, go back to the office, drop off testing results, that kind of thing. So you should say that not every job is conducive to remote work. An admonition that remote work is not an entitlement, and that you reserve the right to require office work, and clear expectations for both the employee and the employer. You want to make sure that there's no misunderstanding about who is responsible for what. And just so you know, we've provided a sample remote work policy in the materials. Feel free to use that at your discretion. And let's go to the next slide, Laura. Scheduling, the key word with scheduling is flexible. We encourage employers to be very flexible with scheduling leave time and remote work policies. We had a question about designing a phased-in staff schedule and whether we could allow someone to stay at home because it would allow us to socially distance. And as long as you have a legitimate non-discriminatory reason to allow someone to stay at home or to require someone to come in, then you should be fine. Last question was about equipment being used for remote work and whether we have to pay for that equipment. And the rule is not usually, unless in the very unusual circumstance that requiring somebody to pay would bring that person below the minimum wage. you don't want to put yourself in that position. But just generally, think about Jeff Goldblum again. Just because you can do it doesn't mean you should. If you're going to require people to work from home, pay for the reasonable costs associated with that work. It'll save you a lot of headaches later. And with that, I'm going to let Laura take us home.
Thanks, Kyle. So as I mentioned earlier, we both have new laws to contend with and new considerations for existing laws. So let's start with the new law, which is the FFCRA. So as many of you I'm sure are aware, this law applies to all employers with fewer than 500 employees, and it provides up to 12 weeks of public health emergency leave to eligible employees. And really how this breaks down is into two types of leave. There is the emergency paid sick leave, and then there's the expanded family medical leave. So for both these type of leaves, a way that they are different than the type of leave that you might be accustomed to under OFLA or FEMLA is that this leave is paid. And to add a little insult to injury, there's been some recent guidance that public employers are not going to get the tax credits that private employers get for providing this paid leave. So that's somewhat disappointing, and I'm not exactly sure why that decision was made, but that's the world in which we're living. So you have to provide this leave, and it has to be paid at different increments. If you're providing emergency paid sick leave, then that's 80 hours, or for most employees, 2 weeks of full pay. And that is pay that is in addition to any other paid sick leave or PTO or anything else they would be getting. Then separately, there is up to 12 weeks, but the first 2 weeks are unpaid, so I really think of it as 10 weeks. 10 weeks of expanded family medical leave, and that is at 2/3 pay. And this type of leave, I think, has raised a lot of questions for employers because one of the eligible reasons for qualifying for this type of leave can be that your child school is closed or daycare is closed because of COVID-19. Now, you'll recall earlier when we were talking about Jane, we went through the list of qualifying reasons, and there's a number of them, and a lot of them relate to what you might imagine. If an employee themselves is sick and showing signs of coronavirus, or they're caring for someone who's sick and showing signs of coronavirus, that's more familiar, I think, with the FMLA, OFLA type of leave. I think what's quite different and raising questions for a lot of employers is what we do with children staying home. That affects a lot more people and creates a lot of issues. A couple things to keep in mind about this leave. The first is that it's not in addition to FEMLA or OFLA. So don't think now people have a whole nother 12 weeks of leave. If they've already used all their FEMLA and OFLA early in the year, it's exhausted. And I will tell you that there is a very, very useful frequently asked questions page for the Department of Labor. It's up on the screen so you can see it, you have new materials. I highly recommend you go there because likely your questions will be answered. So 2 questions that we did receive related to FFCRA are the following. The first was basically regarding the 10 weeks of leave and whether that can be taken intermittently. So if you have a child that's home because schools are closed, or now that it's summertime because summer camps are closed, do you have to let them take that in all 10-week periods? Can they take it a day at a time, hours at a time? How does that work? And here's the answer. If the employee is teleworking, so you have a telework arrangement, then they can use that leave intermittently. And the example given on the FAQs is in 90-minute increments. Maybe they're unavailable to work from 1:30 to 3, because that's protected leave, but then they work from 3 to 5. So if you're teleworking, they can use this leave intermittently. And then, however, if you're working back in the office, the guidance is that it should be used in full day increments. However, if the employer and employee agree to a different arrangement, that is totally fine. And in fact, and I've never seen this before, but the Department of Labor has language in there that says, we encourage all employers to be flexible when working with their employees and come up with flexible arrangements, and we will support that. And just if anyone's taking notes, if this was your question, the FAQs that apply to the specific question are 20, 21, and 22. So then the next question was, okay, well then what does this 10 weeks mean? Does this mean, like, do you count it in hours, days? How do you count it? And basically it's in hours. So you take however many hours an employee normally works, let's say it's 40, And then it's 10 weeks, that's 400 hours. So that's helpful if you're doing the incremental leave. You can deduct it by hours as opposed to, like if someone takes 90 minutes in one day, that's not like an entire day is gone and then they only have 79 more days. That means that an hour and a half is gone and they still have the other hours left. But again, there's a ton of FAQs on this, and in particular, I'll point you to FAQs 48, 80, 82, 83, and 84. But bottom line, I would recommend everyone check out those FAQs because they're quite helpful. So my remaining time, I just want to make sure that people understand something important about workers' compensation, because that's come up quite a bit. So Kyle mentioned earlier remote work policies. Something to keep in mind is when your employees are working from home remotely, they are covered by workers' comp. So if they get injured at home, they could have a workers' comp claim. And an example that Kyle and I often talk about is a case out of the Court of Appeals from 2011 with J.C. Penney, where an employee went to get fabric samples from her garage and she tripped over her dog, and that was found to be a compensable claim. In fact, the lower court said it wasn't, and the appeals court reversed it. So make sure that you are aware for workers' comp that your employees have a safe workplace at home. So that's a new consideration in this COVID-19 era, because those claims can be compensable. Another thing to keep in mind is whistleblower claims. If you have an employee who, think about Jane in our earlier example, who says, well, I'm just not going to come to work because I don't think it's safe. You can walk through all the process with her and decide in the end that it's not a good fit and that this is the job and you need to come back. But just be very careful about how you document that, because if Jane also says, and I'm going to report you to OSHA because you don't have a safe workplace, that might be a time that you might want to call your favorite employment lawyer because you don't want to deal with any whistleblower type claims. And you don't want to give the appearance that the reason you let her go is because she threatened to call OSHA. So try to be patient with your employees during this time. There's going to be a lot of frustration. There's a lot of misinformation. There's a lot of things we don't know, but really try to walk through it and work through it so you're not running into whistleblower claims. And then in our remaining time, I'll run through one more hypothetical with you all, which is regarding Joe, who has an underlying health condition. So this is different than Jane. Jane just had generalized fear. Joe has an underlying health condition. So in this case, asthma. So what do you do if you have an employee who refuses to return to work and they say, well, I'm at higher risk because I have an underlying health condition? So a couple things to keep in mind here, and I just want to mention before we sign off that I've seen some employers bandy about a policy that they're not going to have older employees return to the office just across the board. If you're over the age of 60, you have to work remotely. You cannot do that. That's age discrimination. There's a recent guidance from the EEOC. You really need to engage and make sure you have a safe workplace for all your employees. So whether it's someone who is older or has asthma, let's look at this consideration. So for Joe, go through first, does the FFCRA apply? And as you may recall with our example of Jane, asthma is not going to fall into any of those 6 categories. So now, if the FFCRA does not apply, is asthma a serious health condition such that Joe would be eligible for FMLA leave? Probably not. We're assuming in this example that the asthma is controlled. He was able to work previously with it, so it's not a serious health condition. And then this will lead you to your final inquiry, and I think this is going to be a really important one, which is whether it's considered disability, which asthma would be, I think, considered a disability under the ADA, whether you have to provide reasonable accommodations, and is telework an example of such a reasonable accommodation? Now, it's going to be harder for employers to say that telework is not a reasonable accommodation when we've been doing it for so long. Here in this example, we said that Joe had to be in the office because the computers he had access for his job, he could not do remotely. He had to be in the office. So in that case, it may be an undue burden such that you don't have to accommodate it. But keep in mind that this is an inquiry you'll need to go through with all of your employees. So as we promised, we went through a lot of information and we went through it rather quickly, but we hope that this framework has been helpful for you all. We hope that we've helped you issue spot and know what to look out for, and that between our conversation today and the resources that we provided, you have a good framework to go forward. And of course, feel free to reach out to either one of us at any time with any additional questions. Kyle, anything you'd like to add?
No, I would just like to echo that and thank everybody for joining us today. And please don't hesitate to reach out if you have any follow-up questions. I know there could be many. So thank you all very much.
Thank you.
Thank you to our presenters. Vanessa told me that she will be sending out the materials to everyone registered with their email, so you should receive those shortly. For some reason, the webinar link for handouts did not work properly. Also, there's a recording of this on the OrCP website. Thank you all for joining today.
Thanks, everybody.
Thank you.